and thanks for joining us as we finish up January with the Elville webinar series. Hope you're somewhere warm. It's Friday, January 30th, and our topic today is one we've done probably 100 times over the years, but this time repurposed a bit. It's called Protecting What Matters Most, Estate Planning and Elder Law Explained. And there's nobody better to walk us through this discussion than our Managing Principal and Lead Attorney, Stephen Elville. How are you today, Steve?
Jeff, I'm very well, and I'm cold, but I'm in here in conference room 1, and you may be wondering why am I wearing a blue and bright green tie, and I thought about that myself, and I said, well, I think I'm in Alaska. It's so cold, and I'm trying to emulate the Northern Lights. So there you have it. That's why I'm wearing my bright tie.
Well, the Northern Lights are beautiful, as is your tie.
Thank you.
So we have a few housekeeping items. We encourage your general questions throughout. Please note them in the questions panel on your screen, and we'll pause periodically. And yesterday by email, you should have received the slides that Steve is going to be referencing. If you didn't receive this email for some reason, the slides are in the section marked handouts to download at this time. And everyone will also receive a post-webinar feedback email right after the presentation. Please take just a couple minutes to fill out this very brief yet important survey to give us your feedback about today's presentation. And a question for you: have you achieved your planning goals, or have those goals shifted since you last looked at your planning? Here at the firm, we're a leading resource for your family's planning needs. So whatever it may be, if you're starting from scratch, if you haven't looked at your plan in 20 years, special needs matter, administration, whatever it may be, Steve and his team are here to guide you through the process every step of the way. So we'll move through a brief introduction and we'll jump right in. We have a lot to cover. So we are Elville & Associates. We were founded in 2010 in Columbia by Steve. We have many different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law, guardianship, tax planning, and many more. We have 14 attorneys, 13 staff members in 3 locations, and we're coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at Elville & Associates, and just one of a few ways that we do it is through our planning processes with our clients, and we have different programs to suit all families and individuals here at the firm. We also, as you see, offer educational webinars and workshops in the communities that we serve each year. Just yesterday, we had our first client event planning committee meeting. We have a big client event, if you don't know, in November of each year, and it takes almost a full year to plan for it. So we're looking forward to it very much, and we'll have some information about that coming out pretty soon. Also, we have an accredited client care program here at the firm, one of only 2 firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. And just a bit about Steve. I could talk all day about Steve, but I'll keep it to about 30 seconds. He's worked as an attorney for the past 25 plus years, has been centered in elder law, estate planning, and special needs planning, a member of many different national professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, Wealth Council, nationally recognized peer groups, and many more. Steve works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned presenter, offering many webinars, workshops, presenting at conferences, continuing education events throughout the year. And he was also named to the Maryland Super Lawyers list for a 10th time. Oh my goodness, I updated that. It's actually 11th time and 10th consecutive year in 2026, I should say. So sorry about that, Steve. I'm shortchanging you. Steve also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charity that he founded in 2014. I am very fortunate to be a part of that organization. I have, I'd say, probably about 40 instruments in my office right now that are in various stages of being refurbished so we can distribute them out to school music programs and other organizations. So if you want to learn how we work to make a musical difference in the lives of children each day, please reach out to me. I would love to share our story with you, and that's a great one. With that, I'll turn it over to Steve. I'm going to make you the presenter, Steve.
Thank you so much, Jeff, and thank you for all you do and collaborating with me all these years on these thousands of webinars we've done together.
It is my pleasure.
Educating our clients And I'm taking over the screen now, and I'm going to bring up my desktop here, hopefully, that will let me get to my slideshow. And Jeff, I knew it was cold when I saw you wearing a coat the other day, so don't usually see you wearing the coat, so I know it must have been cold.
It
All right.
does take a lot, but I'm not crazy. No,
Well, good morning, everyone. And we know your time is valuable, and you're getting your day started with us here on a Friday, as we are at the end of January 2026, which is very hard to believe. Welcome. Thank you for including us in your day. We're going to be efficient. We're going to cover a lot of material today, almost so much material that it's just going to be practically impossible to absorb it all. But I want you to use the presentation as a tool. I want you to maybe even print it off for yourself and keep it somewhere. If you're a person who, like me, you have to print something off to be able to store it, or store it someplace else. Jeff will send it to you electronically if you haven't already received it. And I also want you to know that Jeff is a moderator who is of an expert caliber, and he has worked with me, and we've been on the road together and done virtual presentations like this for years together. This is an interactive workshop, even though we have a lot of material to cover. If you have a question, please ask. And I just want to again say it's a privilege to be with you, to lead the attorneys and staff at Elville and Associates, and to be able to bring you education today. And we want to be a resource to you. We want to be educational, and that's what we're going to do today. So as we start, we're going to be efficient. We have a lot to cover. Again, I thank you for attending. I'm going to start off with a couple of questions, and these are rhetorical questions. If you have a pad of paper, a legal pad, an electronic tablet, your cell phone, whatever it is, please make notes. Please write down something that's substantive that you might want to remember and take away, or you can always email us if you have questions. But I want to start off by asking, why are you here? What has brought you on a very chilly Friday morning here in Maryland, wherever you are, by the way? What has brought you here to this workshop? What are your concerns? And as we talked about in one of the first of a series of workshops that we did a couple of weeks ago about estate planning is about love, I'm going to ask you, who do you love and what do you love? What is a concern of yours? A series of questions, really. And as you think through that and get grounded, you know, from all the news and all of the problems in life that we face every day, and all of the snow and ice and the children and grandchildren staying home from school. And Jeff tells me the schools where he lives are back on today. So, you know, we're in a very busy world. So get centered, get focused on what has brought you here today. And if nothing else, at the end of this workshop, we're going to show you that even though there's a lot of material, that estate planning is really just a series of steps. And elder law is a series of concepts that has to do with aging. So we're going to jump into this now, but I want to ask you that series of questions. Why are you here? Do you have an existing estate plan? Are you contemplating estate planning or other planning? And all planning, as we're going to find out, is goal driven, G-O-A-L. What is my goal? Who do I love? What do I love? Why am I here, and why am I concerned about this? All right. Remember, this is not legal advice today because we are not technically in a attorney-client relationship, but we're in a kind of a high-level educational mode here today. But we can enter into a legal relationship as attorney-client if you need to consult with us, or we can help you collaborate with another attorney who might help you in the particular area that you need help in. So this conversation matters. And Jeff, I thank you for repurposing our slides today. Most estate plans fail, but not because of your bad intentions or someone else's bad intentions, but usually it's because a lack of process. So process, I want you to write a big P. Process is important, and a big G over here. Goals are important, but it's usually a lack of education. It's a lack of coordination. It's maintenance that's required, but never really done. So estate planning is really about a process, and it's not just a transaction. Now, what we're going to cover today is that a true estate plan is really about what I just said, process. Many estate plans fail in one way or another. It could be in the funding and coordination of assets. It could be because the documents were never updated. It could be because of changes in the law. We're going to talk about all that kind of thing. We're going to talk about wills versus trusts, which is one of the most fundamental questions people in the United States and around the world have. And we're going to talk about the critical role of financial powers of attorney and so forth. So advanced directives, financial powers of attorney, we're going to talk about that. We're also going to talk about elder law and what that is. Jeff, I apologize. I think that they must be doing construction in the room next door to me. So if that continues much longer, I will switch rooms because our office is adjacent to another office here and looks like they might be doing construction today. So I will be mindful of that. So back to the presentation here. We're going to talk about taxation and asset protection and the foundations of elder law. Again, just to give you a foundational concept of these ideas today. We're going to talk about how to deal with updating older documents and how those non-updated documents can create problems. We're going to talk about something, and maybe this is another big word, a letter to write, an F, for flexibility. So goals, process, and flexibility. Flexibility is one of the big things in the law today as it relates to estate planning. And we're going to talk about how to get started and how to think in terms of a process. So as we move forward here, estate planning is not a set of documents. I've got a legal pad right here, and if I said, well, that's a set of documents right here, well, most people think that is an estate plan. Well, in a way it is, and in a way it is not. An estate plan is more of a thought process. It's more of a collaborative process with your advisors, your lawyer, your CPA, your financial advisor, and others. It's not just a static set of documents. This is one of the main things to remember. Some of you are perfectionists. Some of you are worried about a lot of things, and you're worried about doing it perfectly. And I want to release you from that worry. I want you to think in terms of getting your planning process started or restarted, and I want you to give yourself permission that it does not have to be perfect. You can build in the best ideas and the best planning for today, and you can build flexibility into that plan in ways that we never could have imagined 25 years ago. And then you can give yourself the permission to change your estate plan over time. So your estate plan will adapt over time. And when you do that, that is a good process. That's a life process. It's not a transactional process. We are providing clarity and certainty for loved ones, people we love, organizations we love, causes that we love, family as a whole that we love, to preserve their autonomy and your autonomy during your life, to reduce costs, reduce conflicts, protect assets in some cases, protect family relationships or deal with specific family relationships. Here's a big one at the end. How would you like your plan to reflect your own personal life, your values, your legacy, the things you've accomplished and believe in? Again, what you love and have stood for in your life. These things can be translated into an estate plan. Now, effective planning is, like I mentioned, the G word, goal driven. All planning, whether it's foundational estate planning or advanced estate planning or tax planning, everything is goal driven. And I think when we focus on that, it helps so much for how we should think about our planning. So everything begins around your family structure, your health, your values. There is no one size fits all planning. Even though we have a lot of automation today in our world of how we can construct documents, but there's nothing that can substitute for legal counseling, and there's nothing that can substitute for your own values, your own goals, and how you might express them. So if we wanted to look at estate planning as a process, we might say, well, there's 3 phases. It doesn't really matter how many phases. What matters is that it's just not one phase. So here, we're going to design and implement a plan. And that begins with a commitment, that begins with a goal, that begins with focus. And then phase two is what I mentioned. If you have a plan that can be maintained, you have a mindset that says, I'm not going to lock myself into a one-time process that fits all forever. Think about that. We live in a world that's changing by the hour, by the minute. The news is changing by the hour, the minute. The Congress and the things that are being implemented in our laws, tax-related, non-tax-related, financial-related markets. Everything is changing. Family relationships are changing. People's health is changing. Your location where you live may change. Your children may live in different states. Maintenance and updating of the plan is crucial. And now, when we finally pass away, hopefully many years from now, our administration of our estate is actually going to be the way we want it to be. But we don't want to forget that we're still alive and we're still probably going to live a long time because people are living a long time. So estate planning is a lifetime process to construct what happens at our passing, but we also have to be mindful of what happens during our lifetime. So documents alone don't work. Many of us have worked in estate planning firms that emphasize documents as the planning, but we know that this will not work for reasons I mentioned. Family dynamics and health changes, assets change over time, tax laws change over time, and plans must adapt. So what is really our goal? Our goal is to have a plan that's ready to work when we need it the most. Many times we have lifetime issues. It could be a pre-crisis situation. It could be a crisis situation. Do our documents work when they are needed? When we pass away, depending on how we've structured those documents, how will our fiduciaries understand and implement? Will it be stressful or will it be smooth? Will it continue to work in the years to come? Now, as I mentioned, we have traditional ideas of planning, or we have that documents are the plan kind of idea. Well, when we have that frame of mind, it tends to be one phase, it tends to be one dimensional, it tends to not have any maintenance and updating, it tends to not have any client education, it tends to not have any collaboration with other advisors. And in the end, it usually is more expensive. So we just don't want that for lots of reasons, and we'll continue to move on. The process-driven plan, or the educational-related plan, is really an emphasis, again, on education, maintenance, and updating, the collaborative team, the family, goals and values, making sure people are educated, making sure fiduciaries are educated. Quite a big difference in the way of thinking of these things. And again, every family is different. Every person, every couple is different. So we want to avoid this idea of plan failure, which usually represents an increased cost. It could represent court involvement. It could represent family conflict, or it could represent that family conflict was never addressed during your life. And it is a lost opportunity. If we intended to have asset protection, if we intended to do planning for protecting our children or grandchildren from divorce and other creditors, or other planning, could be special needs planning, it could be charitable planning, it could be non-charitable special purpose planning, it could be lots of things, but there is a potential for failure if you do not pay attention. And of course, nowadays in the world, we have a lot of things going on that are concerning, and now is the time to either implement a plan or to review your existing plan. Now, I'm going to just now transition into the second phase of the presentation, which is what happens if we have a will. So this is one of the basic things to kind of get your mind around if you don't know about this. Wills are subject to probate. Now, what is probate? Probate is the process of proving a will to be valid. Maryland is a traditional probate estate, or a state, I should say, a traditional probate state, and so are many surrounding states. My understanding is that Virginia has streamlined probate compared to Maryland. I am not barred in Virginia. But I know in Maryland, we have the public oversight of probate, which is really just the process of proving a will to be valid. Now, let's talk about what is in probate as far as your assets. And many audiences I speak to these days have a much more educated view of this than in the past, I find. So let's say that you had a life insurance policy and it has a beneficiary. Does that go through probate? The answer is no. But if that life insurance policy had no beneficiary, that's going to go through probate. A retirement plan that has no beneficiary, and hopefully that is usually not the case, that retirement plan will go through probate, generally speaking. What if we have a joint asset? Does that go through probate? You're a joint owner with someone. The answer is no. That's going to pass to that person without probate. What if we have an asset in our name that has no beneficiary and no joint owner? Does that asset go through probate? So let's say you have a piece of real estate, it's in your sole name, it has no joint owner, and it obviously has no beneficiary. Well, that is going to go through probate. That checking account that's in your name with no beneficiary and no joint owner, that's going to go through probate. So probate is about assets that have no joint owner and no beneficiary, and now the public oversight of that is the probate process, whether a person has a will or not. If a person has no will, that is a intestate estate. That's an estate that's going to pass by the laws of Maryland in this case, since we are in Maryland. And the cost of probate is going to vary depending on where you are. In some states, it's roughly 5% of the probate assets. In some states like New York, I understand it's 6 or 7%. In Maryland, if we look at the statutorily allowed fees, it's roughly 4%. That does not mean that probate will actually cost you 4%. It just means that those fees are what is allowed in probate in Maryland. So I would think in terms, generally speaking, of 4%. And as we think about a will structure, we see that here in this slide, a will is the driving force. It is the thing that controls what happens at our deaths. But are people living longer these days? And the answer is clearly yes. So on the sides of that will, we have financial powers of attorney and advanced medical directives. Here is a question for you. You won't be able to speak to me directly, but I want you to write down, what is the most important document of all these documents in the eyes of an attorney, of an estate planning attorney? Now remember, all these documents are important, but in the eyes of an attorney, one of these documents is more important than any of the other ones. And I will let you guess on that, and I will come back and give you the answer here in a few minutes. Now, as we continue to go through our slides, some people are going to use what I call non-probate transfers. And most of you on this webinar know about this. Beneficiary designations, joint ownership, payable on death accounts for bank accounts, transferable on death accounts for brokerage accounts, in trust for accounts in some states that are similar to TOD or POD accounts, and life estate deeds. There's nothing wrong with these transfers. Many of you use these. Many of us have these already in our lives, but we don't want to rely from an estate planning point of view. We don't want to rely on these designations as the sole way of transferring assets, because to make a very long story short, these transfers have no flexibility. These are one-way streets that don't account for things that can happen that suddenly change things, or incapacity planning, or asset protection planning that is needed. It is just a one-way street, and they work the way they're intended, but there are some downsides. So most people will use a will-based plan or a trust-based plan. And now we'll talk about a revocable trust. So wills versus transfer on death or non-probate transfers versus what happens if we use a trust. So I want you to think about a revocable trust as a substitute for a will, okay? And if that trust is done correctly, if it is done correctly, okay? It is going to avoid probate. It's going to be private in most circumstances. It has to be funded with your assets, or your assets have to be aligned. Now, that particular trust, that revocable living trust, which is nothing more than what? A substitute for a will, or we might say it's a fancy will substitute, okay? That substitute for a will does not protect from creditors. It does not provide asset protection, but it is a tool to funnel down assets without probate. And for many of you, this is going to be preferred, not for everyone. It has an administration at your passing, just like a probate, but that administration is simplified if it's properly done. That administration is private, and the cost should be less than probate if everything is done properly. And as we look at your goals, this is going to determine, do we want to have a will-based plan, or do we want to have a trust-based plan? Again, this is going to be goal-driven. It's going to be fact-driven, depending on the kind of assets you have and what your particular life situation is. Here we see that the revocable trust has taken the place of the will. So the revocable trust is the driving force here. The will, as you can see, has taken second place. The will is in the background, and the revocable trust is driving this. And remember, it's going to be a beautiful thing, so to speak, for estate planning purposes. It's a wonderful tool, and it avoids probate. It works the way you want it to work, as long as it is funded with assets. Now, let's stop right there. Do we put retirement plan assets like IRAs and 401ks and 403bs, do we put those kinds of assets in a revocable trust? And the answer is no. We cannot retitle those kinds of assets into a revocable trust. But everything else, non-retirement assets, would transfer down, while the retirement assets and life insurance assets are funneled down however you decide it should funnel down to your spouse if you're married, or other beneficiaries. So we want to provide for non-probate, but we can only do that if the revocable trust is properly funded. So what we want to make sure of is understanding that funding, so maybe this is another F. We had flexibility, but now we have another F, funding. A plan without funding, a plan without alignment of the assets is not going to work. So let's talk about wills. A lot of people think, well, see, if I have a will, how can I retitle assets? So if you have wills, there is no retitling of assets. But there is a second step, the funding step. So here's the will, you created it, you're happy with it. Now the beneficiary designations for life insurance and retirement plans have to be correct. So a will actually has two steps, in my opinion: creation and funding, or titling, or retitling the beneficiary designations, redesignating. With the revocable trust that we talked about, we have the creation of the trust and the actual retitling of assets into the trust, and the beneficiary designations of the retirement assets and life insurance. So funding is not only something that must be done when the plan is created, it has to be maintained over time as you accumulate new assets or change situations. The funding issue is illustrated here. Let's say we have the greatest plan in the world. You went and saw the world's greatest estate planner. You were very invested and committed to the planning. You did everything correctly, except you had your assets titled a certain way. So you see, we have the documents, and the documents are designed a certain way, and then we have your assets. So the question is, how are your assets titled? Are your assets going to flow? And I'll go to the next slide. Whoops, I'm sorry. Are the assets going to flow the right way? See here, the assets are flowing in a way that is contrary to the will or trust. So we want to make sure that whether we have a will or trust, that we've addressed how the assets are going to flow at death. Because if the assets flow in a way that's not congruent with the plan, the assets may end up in a place where you were not exactly happy with how they ended up where they ended up. Now, as I mentioned, and as we say here at Elville and Associates, estate planning is not just about what happens at death. It's about not just about your legacy. It's about lifetime planning. We plan for life. And planning here for life means understanding that we can build in flexibility. We can have powers of attorney and advanced medical directives with our design, with our thoughts and ideas, with our agents, our trusted fiduciaries who are going to make decisions for us if we are incapacitated. And what is the net result of all of that? When you plan properly and you have agents under your financial powers of attorney, agents under your advanced medical directive, and of course, proper personal representatives under your will, proper trustees, proper guardians if you have minor or disabled children, you yourself are avoiding guardianship. You are a person who has a right of self-determination. You have years ahead of you to live. You may or may not ever become incapacitated. But if you become incapacitated, God forbid, you have the authority to be in control of your own self-determination. And that is through thoughtful powers of attorney and advance directive. Now, I'm going to stop and give you the answer. Of the will, trust, powers of attorney, advance directives, or any other estate planning documents that I have mentioned so far, what is the most important document in the eyes of an attorney that does estate planning? Well, the most important document is the financial power of attorney, because arguably this is going to be the thing that you can build most flexibility in, most planning in, should you become incapacitated, for what you would want to happen, not only for yourself, but for your spouse and others who might be dependent on you. So all the documents are important, and we have clients who think the advanced medical directive is the most important to them, and that's never going to change. But in theory and concept, the financial power of attorney is the most important of all the documents. And here at Elville and Associates, we treat our planning as such, and we spend time designing those documents. Remember that for advanced directives, you can build as much customization as you wish for your health care. And in financial powers of attorney, do not fall into the trap of thinking that all financial powers of attorney are the same. Far from it. Powers of attorney can be plain vanilla many times, or they can be very robust to accomplish goals that you may want to have accomplished in the event of your incapacity. So we have statutory forms in Maryland since 2010. These forms are growing in enhanced powers as the legislature over time adds more powers. But generally speaking, they are not going to be as broad as what we might call general powers of attorney. So those of you who know about these forms, we know Maryland has statutory forms, just like Delaware, DC, West Virginia, New York. And we have a variety of couple of those different kinds of forms, but we're going to also want to look at what broader powers do we want, what more enhanced powers do we want, and some of those powers might be very, very aggressive. And so we want to make sure that as we build powers of attorney, we really appreciate the fact that we're giving people oftentimes tremendous powers. And some of those powers are listed here in these slides. And of course, you do not have to give someone those kinds of powers. You can give people limited powers. But generally speaking, as we think about the future, we do want to be thoughtful about how much flexibility to provide. And this is going to be on a case-by-case basis, depending on who your agents are, what your goals are, and what you're trying to accomplish, and who you have in your life to depend on. And so these things are very important in design. Powers of attorney can be effective immediately, or they can be effective only upon your disability. Also, powers of attorney can be escrowed. They can be held by your attorney until such time as your agent may need those documents. So everything is going to depend on your personal situation and how you see the development of what we would call the common law over the last couple of 100 years to get to the point where we are now, where you can design these documents and, subject to how your bank views them, how the law says that you have the power to enforce them under Maryland law. We're living in a pretty good place right now where powers of attorney are more regulated than they once were, and you can decide, again, how they should be implemented and when. As I mentioned, the healthcare directive is the most important document for some of our clients, maybe for you. You need to understand that this form, whether it's in the Attorney General's form that we use, because we don't want to reinvent the wheel, we want to make healthcare decisions very well straightforward so people can understand it. If you are in a crisis, healthcare professionals can understand it. And of course, your agents would be advocating for you. So we want you to put personal input in there. You don't have to, but you can customize it, because remember, with regard to healthcare decisions, your agent is only going to know what you told them during your life if you don't articulate it here in the healthcare directive. And of course, the same principle applies. How much flexibility do I want to build in to my healthcare decision making? And of course, as a person who's done tens of thousands of these with clients, we do have some nuances that we can suggest, but largely we want you to think through this in private and just consider this a very private document for yourself. The MOLST form, which became effective in Maryland law around 2013 and 2014, many of you have seen this. It's required in Maryland. You should educate yourself about it. MOLST, the medical order for life-sustaining treatment, is above and beyond today's workshop, but you should avail yourself of information about this. We can provide more information. You can also go to the Maryland Attorney General's website to learn about MOLST. Jeff, I'm going to stop just for a second. We have about 22 minutes. We're getting ready to shift gears now into the tax and elder law environment of the world we're living in. Are there any questions, Jeff? And should I just take a sip of water and keep going?
No questions as of now, Steve, though of course they are strongly encouraged.
I gotcha. Well, that means that we have people that are contemplating what we're saying, and please let us know if you're having any technical difficulties or anything. So I'm going to switch now to the tax environment in 2026. We are living in an unprecedented world of estate tax exemption at a very high level. Many of you were watching and over the summer as the One Big Beautiful Bill Act was created, OBA we call it, and OBA has some winners and losers, but on the estate planning side, it's all winners. And what I mean by that is we now have a permanent $15 million federal estate tax exemption per person. That means if you are married, you, through the proper use of the exemptions, you can exempt $30 million for federal estate tax purposes. And if you live in Maryland, we have a $5 million Maryland estate tax exemption, and you can, through the proper use of something called portability, and many of you have heard of that and many of you have not, you can use $10 million for Maryland. So we're going to watch the legislature very carefully this year, which is in session now, and we're going to make sure we're watching in the event that the Maryland estate tax exemption could be reduced. It was almost reduced, but it was rejected last year. So we still have $5 million in Maryland, which is very good. Some states have only $1 million, like Oregon. So we're very, very lucky in Maryland to have that. And we're also lucky that we have portability in Maryland. Many places do not have portability. So we're very lucky there. So just know that we're living in an unprecedented environment for the proliferation of estate planning legacies and wealth in this country through estate planning. And that is because of OBA and the making permanent of many of the estate planning laws that were really subject to sunset, but those have now been made permanent. Through estate planning, you can have marital control over assets. You can leave assets to your surviving spouse if you're married in a way that is advantageous for control and also estate tax. and you can provide marriage protection. There are ways of planning for advanced estates, moderate estates, and as we're going to see, planning for Medicaid and other asset protection as we are looking at how estate planning juxtaposes up against or bumps up against elder law and special needs concept. But just take away from today that from an income tax point of view and from an estate tax point of view, due to OBA and the continuation or proliferation of very favorable estate planning laws, we are living in an unprecedented environment for very high level estate planning, even for those on the fundamental to moderate levels, not to mention the advanced levels. Now, a lot of people will ask about this bumping up against thing that I just mentioned. What is the difference between estate planning and elder care planning? Well, it's very simple in a way. We have a proliferation of aging population in this country since the 1990s, and there is a need for estate planning to evolve from just what happens at my death and how I'm going to leave my assets to, well, gosh, people are living a long time, generally speaking, the cost of long-term care. What are we going to do to preserve assets or to be able to provide for flexibility in elder care planning, providing for enough money to pay for the cost of care, and in special needs planning, more and more as every day goes by, we are aware that in special needs planning, parents and families may have to take on the burden of providing for how their loved one will be cared for in the future, even though the loved one may qualify for means-tested public benefits. Those means-tested public benefits may not be very effective in some cases in the future. So we are living in a world where the juxtaposition of how to plan for death and incapacity now juxtaposes up against the idea of aging and how we're going to pay for the cost of care and what are our goals for this moderate wealthy family, let's say, or lower wealth family that is having to deal with the cost of care. And of course, Maryland is one of the less favorable jurisdictions to live in as we age, because Maryland does not pay for anything for care except in limited circumstances short of a long-term care skilled nursing home. So we are in a disadvantageous place in Maryland for our general population to have long-term care that is financed by state government as compared to other states like Delaware or New York. So we do have to plan very carefully as these two planning areas bump up against one another. Ideally, what we want in elder law is to plan with as much flexibility as possible so that even though you yourself may not have entered into a elder care centric plan, that your plan can evolve into a plan like that through the powers that you've given your agents.
Steve, can we pause for a couple of questions?
Go right ahead, Jeff.
All right, thank you. A few good questions here. So the first one is, what does portability mean for Maryland estate tax exemption?
Thank you very much. Portability means that if you're married and your spouse dies and you're the surviving spouse, you can choose to elect portability, meaning you can port your deceased spouse's unused exemption amount, and let's say in this case, $5 million, you can port that over to yourself, and now you have your estate tax exemption, let's say of $5 million right now, plus you have the estate tax exemption of your deceased spouse. So now you have 10 million of exemption, and I want you to think of that as a blanket or umbrella over your tax liability for potential tax liability in Maryland. So that is a very high exemption, considering that Maryland has a state estate tax and many states do not. But that's a pretty high state estate tax exemption and the portability of that. And at the same time, you would be porting the $15 million exemption of your deceased spouse that would come over to you, and you are kind of locking that in, the 15 and the 5 million.
Well, thank you. And next one is, If I know I want to designate charities as partial beneficiaries but don't have specific organizations, how is this handled in documents? And along those lines, is it better to have a charity listed as a beneficiary of a retirement account or as a beneficiary of a trust?
That's a wonderful question. So the first answer is, of course, it's better if you can articulate who this would be, these charities. In estate planning documents, we can give very clear instructions, of course, to your trustee that they may distribute assets to charities that maybe you did not describe exactly who they are, but maybe the purposes that you're trying to accomplish. Yes, it is possible to do that. Now, in some cases, if that's not done well, it can put the fiduciary into some hot water there, right? Because charities, once they are designated, they have an expectation. And then if it's not 100% clear, on the other hand, the other beneficiaries of a trust, if there are other beneficiaries, could put that trustee under a lot of pressure. So we want to be very clear about what they can and cannot do if you're not going to be specific. Now, back to retirement plans, yes, if we wanted to simplify charitable planning, and of course, charitable planning can be complex, but if we wanted to very, very much simplify it, there's pretty much no more powerful way to leave assets than a direct beneficiary from a retirement plan to the charity, because that is a direct point from point A to point B. It's not running through a trust before it reaches the charity. And of course, it can do that, but there's always a possibility when that is running through that trust, if it's not done exactly right, it could trigger tax on the IRA or the retirement plan money, rather than just going straight from point A to point B, and now that charity receives the money with no tax. So those are two really great questions.
Thanks, Steve.
All right, and Jeff, just one last comment about that. That was a wonderful question about charitable giving. Remember that you can set up a donor advised fund with your broker dealer, and you could leave assets directly to that donor advised fund. All right, let's now, in the last final segment of our presentation, let's get into asset protection, because many people are concerned about asset protection today. Asset protection is something that causes people confusion. So when we say asset protection, what I mean is usually creditor protection from general creditors, bankruptcy, car accidents, and so forth, divorce. This is what we would call general asset protection. Now, there are 21 asset protection states now in the United States. Delaware, our neighbor, is one of those. Alaska, Nevada, South Dakota, Tennessee is even an asset protection state. And there are many, South Dakota, there's many asset protection states. What we want to do here is break down the different types of asset protection. So without further ado, let's try to make sense of some asset protection here. You, and the nice person who just asked the question about retirement plans, you have retirement plans, you have IRAs, you have life insurance, you may be married, and if you're married, you have husband and wife protection, tenants by the entireties, let's say, of your property. You also could make a brokerage account, tenants by the entirety. Maryland is a huge tenant by the entirety state, and so is Delaware. This is kind of a fundamental level of asset protection. I would think about lifetime asset protection as these assets. If you have these assets, you are protected from the claims of creditors. Life insurance, if your spouse or child is designated. Annuities, if your spouse or child is designated. These are not available to the claims of creditors. IRAs and qualified plans are not available to the claims of creditors. However, when we leave an inherited IRA to a child or any other person, that person does not have asset protection in that IRA, generally speaking. So we have to understand that there are states like Delaware where we can do sophisticated asset protection during life. But otherwise, if we're just living our normal lives, we have asset protection in these other assets. Tenants by the entirety, a very simple definition would be if you're married and you were to get sued, but your spouse did not, the judgment creditor would not be able to get any part of the marital home or a brokerage account that was titled as tenants by the entirety. So you can see that tenants by the entirety is not bulletproof. If the creditor sues both of you, you could lose that asset, but it is a foundational tool to make sure that if we're married, we should, depending on the situation, we should have as much title as tenants by the entireties as possible. Now, if I switch to long-term care and completely switch our paradigm to a method of thinking called, well, how are we going to do long-term care asset protection? Not just general asset protection. Well, we might use a Medicaid asset protection trust. This is something in some states that is called a income-only trust. This is possibly one of the most powerful tools in estate planning today. Or we could use a variation of that, a veterans trust, or we might use trusts established under wills where, let's say we have a spousal unit and one of the spouses unfortunately has a progressive illness. We need to understand Maryland law with this in this regard, because Maryland law now is very favorable to the use of trusts under wills where we have an ill spouse. We need to understand the 5-year period, which some people call a look-back period. We call it a look-forward period. We need to understand other concepts about what are fallback strategies, where we might be able to use tools to preserve some of the assets, even if we don't end up preserving as many of the assets as we hoped to preserve. But again, through the use of trust, flexibility, and understanding the Medicaid law, we can apply that to estate planning to reach powerful outcomes. Many of you want to protect at death. You have trusts established for children or spouses or grandchildren or nieces and nephews. We are still living in a wonderful environment to be able to do that through state law, through multi-jurisdictional choices that we have, which did not exist 20 to 25 years ago, through the use of special fiduciaries like trust protectors and distribution advisors and other structures, and the common sense use of powers of appointment. And of course, special needs beneficiaries can be protected under discretionary trust. So just realize when we think in terms of asset protection, we can have domestic asset protection in one of the 21 jurisdictions. Maryland is not one of those jurisdictions, but you can avail yourself of them. We can use offshore trusts, such as trusts in the Cook Islands or the trust in the island of Nevis or wherever it might be. But getting back to everyday life, we have asset protection in certain types of assets. We have asset protection that we can implement and plan through elder law strategies. And we certainly can provide asset protection for loved ones at death with careful design. Now, as we really start to wrap up, many of you are now familiar or becoming familiar with the Secure Act, which came out in 2020, was signed by the president in 2019. And the Secure Act has changed a couple of times. And it just means that we need to look at our retirement plans as part of retirement plan planning for estate planning. So in other words, if you have an IRA or a 401k and you are leaving those to people you love, obviously, we need to look at your estate plan 90% of the time to determine what is going to happen in light of the Secure Act. And many of you are familiar with this, and you are familiar with the idea that healthy beneficiaries that are over 21 years of age, most of those beneficiaries are going to have to take retirement plan payout from a traditional IRA within 10 years. So just remember that the 10-year rule is going to apply to most people, but it does not apply to everyone. There are exceptions. So a surviving spouse, a disabled loved one, a chronically ill loved one, a person who is under 21, and a person who is under 10 years younger. A person who is no more than 10 years younger than someone, meaning that's a mind twister, a person who's older than you. Those persons, if you leave them an IRA, they are not subject to the 10-year rule. So we do want to be very mindful, especially when we are planning for chronically or disabled persons and special needs trusts, and also children who are under 21. So most trusts, many trusts, are created when the laws about retirement plan rules were old, the old laws. And the old laws were so favorable And many of you are not going to be happy about this, that your healthy adult children are going to have to pay tax in 10 years. So there are things we can do. We don't have tons of things we can do, but there are things that we can do, like Roth conversion or life insurance trust planning. There are things that we can do, charitable planning. There are things that we can do to try to deal with the Secure Act. So if you have not had your estate plan reviewed in light of the Secure Act, then that's certainly something that is not hard to do. And then to the nice person's questions here earlier, retirement plan accounts are heavily taxed, but not when left to charities. Charitable goals, especially in today's world, charities need your funds so much because of the shift back to the private sector to fund charities largely, and public programs and music and so forth. Please think about your charitable giving, and I know many of you already do, and we are, the charities are so appreciative of that. So with the Secure Act, we want to be more thoughtful than ever before, and now, if you have not had planning updated since 2020, this Secure Act thing is something that might drive your updating. As we wrap up, we want to remember that clients must be taken care of. If you become a client of a law firm, that law firm needs to take care of you, advocate for you, and advocate for you to have a planning team in partnership. No lawyer, no law firm knows it all, no CPA knows it all, no financial advisor knows it all, in our opinion. Collaboration in today's world will lead to success. And communication, coordination, making sure that your fiduciaries are educated and know the team. And as you see the top of this slide, you can see that a planning team might include an aging life care manager or professional. It might include an insurance professional and so forth. So we believe strongly that in today's world, we must have collaboration. And I know many of you believe the same thing. If you do not have a collaborative team, we are here to help you form one. We have a client care program at Elville & Associates, and we're proud of that because we believe educating is important, collaborative team is important. We believe that your constant updating is important, but you can only do that if your lawyers or your team provides a path forward to be able to do that. So in the sphere of law, we want to make sure that we are providing opportunities for family meetings and ongoing client education. We had a wonderful client education event last Saturday at Anne Arundel Community College that, despite the cold and the pending snow that was coming, we had many, many people come out for a really full house, and we discussed many ideas. So we invite you to, update, but also possibly join our client care program where we encourage you to update, and that is really the purpose of it. So please schedule a consultation with us if you have any questions. We're here to answer those questions. We're here to be a resource. Stay confident, relax. There's nothing to fear, because even if you've never met with us before, there is an attorney-client relationship formed when you come to consult with an attorney, even if you do not become a client of that law firm. All the information is confidential, so there is nothing to fear, and you can be confident. Prepare your questions, as I mentioned. Let's discuss your team. Maybe you're a person that has gone it alone. You've done extremely well for yourself. Then we're going to want to evaluate that. But maybe you're at a juncture in your life where you need to reevaluate your team or lack of a team, and we're here to help with that. Again, we are here to help you through our client care program. Our legal technical is what we're proud of, that we are here to provide solutions, but we're equally proud to be able to offer a path forward for continuing client care and education. And again, as Jeff so very well said here, define your goals, take the time to think about what matters to you, who do you love, what do you love, and we're here to help facilitate further resources. Jeff, I'm going to turn it back to you. It looks like we've done a pretty good job on timing, and I thank everybody for your time and attention. I hope you have a wonderful weekend ahead, and we do appreciate you taking the time to be with us. Jeff, I'm turning it back to you.
Very much. Thanks so much for everybody's time today. And now's a great time to get any final questions into Steve. Looks like we do have one, Steve, to start with. And it is, can you discuss the Maryland requirement for spousal share a little bit more?
Sure. So this is a big subject that I'll try to be brief about. So Maryland now has what is called a new spousal elective share. So to make a very long story short, it is not possible now in Maryland to disinherit a spouse. And that is a big subject that is beyond today's discussion. However, this started back in 1994 with a couple of landmark very, very unfortunate situations of spouses being disinherited, and the laws were not tight to protect the interests of spouses. So now the pendulum has swung the other direction, where there are extreme protections for surviving spouses, and the implications for that are, well, of course, most people would not disinherit their spouse, but the implications are that spouses are protected, and they're protected to such a degree that if you ever remarry, you must, which is a strange subject for many people, you must consider the implications of the spousal elective share, and you must decide whether you're going to get a prenuptial agreement, because the spousal elective share is so strong to protect that surviving spouse that if you decided that you remarried but you weren't going to leave assets to that new spouse, you were going to leave assets to your family, then you would have to have a prenuptial agreement, or that spouse is still entitled to 1/3 of almost everything you have. So the new spousal elective share is strong. It has implications for elder law, which are much more favorable, and it has implications for remarriage. It has implications for planning, but it is something to be mindful of, and I thank you for bringing it up.
So our next question is about the client care program, and I can certainly answer this one, Steve, if you'd like to
Yeah, right
chime in
ahead.
as well. Is the client care an extra cost when done when establishing a trust? So the client care program, it's a membership program, and it runs $940 a year. So that's your investment in the client care program. Includes lots of different things that Steve alluded to, exclusive education programs, and there's lots of different discounts and benefits that come with it. If you do sign up when you become a client of Elville and Associates, there's several other benefits. Your funding and asset alignment fee is waived, which is $750, I believe. Family meeting comes with your client care program, and deed work and other services are also discounted during the course of your planning. So if you have questions about that, feel free to reach out to me. We've done webinars on this on a quarterly basis, including another one coming up in mid-March. I'm happy to answer other questions for you. Steve, any other comments?
No, I think that says it. And the purpose, again, of the client care program is really just to encourage you to update, to encourage you to stay informed, and also to children and other fiduciaries so that they can be educated.
We love it when members bring their families, they bring their adult children and their financial advisors to our quarterly education programs. That's what the program is all about. So thank you, Steve, and thanks for the question. So it looks like those are our questions for now. I always send out the video and the slides and other information that Steve referenced as my phone rings here. I'm gonna put that on mute. As I was saying, I'll send out the video and slides and other information Steve mentioned. Our webinar series goes forward. We've got a busy start to the year here. Next Wednesday, the 4th, Life and Long-Term Care Insurance in Today's Marketplace, offered by Max Reamer of the Quantum Group. He's a very high-level insurance professional. This was, I think, one of our most highly attended presentations we did about a year or so ago. So we're going to welcome Max back. February 6th, next Friday, Aging Well, Planning Ahead and Understanding Options with Allison Stanton. She is an outstanding aging life care manager. So we're really looking forward to welcoming her. And then on Friday, February 13th, day before Valentine's Day, Guidance After Loss, Navigating Estate and Trust Administration with Confidence. And that is going to feature the webinar debut of our rising young attorney here, Nick Carpenter. So looking forward to having Nick share his knowledge about estate and trust administration. He does a great job for us here. I know he'll do a great job for you on this webinar. So that is it. Lots more planned in the end of March as well. So look forward to having you back, and appreciate you being here today. Hope you have a really great weekend as well.